Hi, everybody. This is Adam Barrett from Apex Ridge, and we are here with our third installment of Legal Use Case 7. We're here with Frank, Bill, and Jim from White and Williams, and we're going to dive into an even more specific example than we did last time. So first, hi, Frank, Bill, and Jim. How are you doing?
We're doing great, Adam.
Hey, Adam. Doing good here.
Good, good. Well, this is exciting. Actually, so exciting that when we were trying to set up what we were going to talk about, we actually ended up getting excited and diving into it so deep, I had to call time out and say, we got to just hit record because, we're kind of really seeing how looking at it from this much more specific example kind of breaks out the pieces. So the idea is going to be that we are going to pick a hypothetical product and we are going to start with the litigation and what let's hypothetically would have occurred in litigation and reverse engineer all the way back to see how legal use case 7 being applied early in the product development process might have helped. And the idea for the hypothetical product, Bill came up with a really good example. And so I'll let Bill jump into it and begin to describe it and we'll go from there.
Great. Thanks, Adam. So our hypothetical is not based on any actual case. It's just kind of a combined set of factors of things that Jim and Frank and I and our colleagues have run into over the course of our careers. But I'm going to give you the hypothetical of a consumer weed whacker, the kind of thing you might use to trim around the hedges or over by the mailbox. We have in our hypothetical, the manufacturer had tested the product using its own battery, using its own string, and assuming certain information about the user, that the user was an adult, and certain obstacles that the string might run into, rocks and trees and twigs and that kind of thing. In our hypothetical, though, an injury occurred, a rather serious injury, when a 12-year-old was using it on very high grass. He was making little pathways for the kids to run around in. So they had let the grass grow 6-8 inches, and he inadvertently sliced off the string by hitting a cut-off signpost. It was a stop sign that used to be there, and it had been cut off down to about 1 inch above the ground. And as the kid used the weed whacker, the string hit that post, the cutoff post, and the sharp edge of the cutoff post caused the string to break and fly off and hit a little 3-year-old's face, causing an injury to the face and, of course, a great deal of concern. Turns out that the family was not only as an underage user, but the family had also put on a replacement battery from the aftermarket, and the battery was a little stronger than the ones that the manufacturer had tested. In fact, the manufacturer had only tested its own batteries and had not considered aftermarket batteries or batteries that might have more or less juice. It also hadn't tested different kinds of strings. The owner's manual warned against anyone using it who wasn't an adult, but it didn't specifically say that minors or children shouldn't use the product. The warnings that came with the product also said, do not use it in areas of obstacles, but it didn't warn about obstacles like a sharpened signpost that gets cut off. One of the issues for the manufacturer in this hypothetical is that they made the conscious decision not to test outcomes and uses that they thought were beyond what they wanted people to use. What do you think use case 7 might have contributed if they had used that, Adam, if they had given you a call and asked you to come in and do some testing?
Right. So the most fundamental aspect of use case 7 is a shift in mindset, right? That's really what the core of it is in very simple terms, is shifting your mindset. So it sounds like from your hypothetical, they took time to define how the product would be used, how they wanted it to be used. And then they did testing and other programs, I'm assuming hypothetically around that. And, and then had that drive design and other decisions. So one example might be that they have from knowing weed whackers, they have an indexing mechanism for extending the string so that it can't just, when you go to let it go, it doesn't just go flying out like a fishing reel. It goes out an index length, right? And because of that, and knowing where the blade is to cut it out at the end, the razor edge, they know that they won't have a piece more than XYZ come out. And, then they would stop there and say, okay, for whatever trajectory, for it hitting something, hitting somebody, we know it won't be more than a 2-gram piece of, thread. So, so what the UC7 idea would have been, yes, guys, that's how you designed it. That's how you intended it. What if people use aftermarket string, the cutting string, because there's no real great science there. Anybody can take one of your spools and reverse engineer it. It's literally a spool. And what if they have a defect in it? And as it comes out, you get the full length of string flying out. I know you did all your testing and you have a 50x margin on safety strength for that not happening, but that's out of your control. Or the exact scenario you just said. What if it hits something that's not that cutting edge and damages it? And what if? The UC7 mindset is the what if, infinite what if. And, at first you might have somebody saying, well, that's not our problem, or that's 1 in a gazillion. And they're right. It is 1 in a, 1 in a million. I mean, 1 in a million in China, right? Where you have billions of people. That's a lot of instances of it happening. Right? It's not 1 in a million is a very concerning number with this kind of stuff, right? I mean, how many of those litigations you need to go out of business? 1 in a million is, it's used as an expression, but you stop and think about it, and that's bad. So it's that shift in mindset. So what I would have done if I was engaged with that team is I would have said, okay, guys, that's great. You've defined how you want it to be used. We've kind of flushed that out, and you've made design decisions about it. Hard partition. Let's go and get creative. What are all the other, things that can happen? And then I'll let you guys now from your expertise tell me some different things that you think could happen, and then I will give responses that I think I would have if I was contributing in that part of the engineering program.
I think from an IP perspective, from intellectual property, I can be a really good advocate for having the engineering folks focus on the connectors to the battery, or maybe the housing where the string is. And we can talk about having proprietary spaces there so that only their battery will fit in the space, and that only their string will, the string magnet or cartridge or whatever it is, can be accommodated in their string space, so that we can further say, look, we can basically ensure that the consumer can only buy your replacement battery or install your replacement battery or your replacement string. And then there are ways to protect that either through patents and for trade dress. A lot, maybe the parallel you might want to think of are some of the printer manufacturers and the way they require you to use their ink cartridges and the way they have that locked down. That's one avenue I think we can take to help convince the folks in product that this is important to do. And look, there's a benefit of adding some of these limitations in.
Something interesting there is I have only seen in my life one method work where you try to ensure that the consumables are your brand, and only one. And that is to barcode or QR code the replacement, and software within the product verifies it is. Because if you're talking about features, if somebody's reverse engineering a battery to match your thing, they're very likely going to figure out what those features are to bypass. And I've seen that. I mean, what it does is, well, this is a good question back to you. So I have teams that do decide to just stick with things like that. And the end result is, look, we're looking to show that we're trying. Of course, you can't build a safe that nobody can't break into with enough time, right? That mindset that, right. But as long as you see us not leaving your money in a bag on the street, and you see us making a safe, we're trying, let me ask you, I'm very curious. When teams say that back, what would you say in response? That no, you should further pursue to the greatest extent you've ever seen an example of, or?
So, right, there's a spectrum. And on the expensive end of the spectrum is you've got a chip in your component that talks to a chip in your product. And when you have an authorized component, will it actually work, right? That's the most expensive one possible. And that said, I'm not sure it's even all that expensive now because the chips are so much cheaper and they're so much more efficient. And then the chip itself might not even need a battery. So I say
No,
most.
it's actually ink. You can actually do it with the barcode.
Oh.
So like the way you scan a product at the cash register and it knows exactly what it is. Okay.
Right. So I'm just thinking of the weed whacker. So maybe there's an IR scanner there, or maybe there's some kind of near field communication, whatever.
I
So
understand
that's sort of on the one end of the spectrum. And then the other end of the spectrum is it's maybe the size and the shape, which people obviously can knock off, but at least you're doing something to make it challenging. It's not an off the shelf, lithium ion battery that you would just buy from back when Radio Shack was a thing that you would just plug in. Maybe you have a special connector and you do the things you can do to try to make it more challenging for someone, like in Bill's example, to just go ahead and plug in a bigger battery. So on that spectrum, you have probably a few different stops. And I think that from an economics perspective and what we think is a potential for harm, you can talk about where on that spectrum you think you belong. And it sounds like this manufacturer may not have taken those steps to do either one of these things. And maybe it wouldn't have been very expensive to take the least expensive step to perhaps prevent one of these two issues from rising up, the battery or the string not being strong enough.
But I want to corner you. I want to corner you as if you were in the analysis with me and you and I went to go work with a team, right?
Sure.
And the team does to me what I just described, where I say to them, no guys, blah, blah, blah. And they're like, look, we're adding a little, boss here so it doesn't go in without our thing. And I'm like, really? And they're like, look, we tried. Would you be like, if you were on the other end of that lawsuit that happened with that battery, would you be like, you know what, that might be enough to have us not go to trial? Like, where in between what I'm saying and they're saying, would you say for that specific case we're doing, it lands?
When it comes to the strength of the case for trial, I'm going to defer to Bill and Jim on that one. But from an IP side, from a product development side, I am going to talk to the folks who work in the battery sales and who work in string sales. And from them, I want to know what's their margin on those two pieces. How many do they plan on selling during the life of the product? And from them, I'm going to take information that's going to help me prove my case internally to the client that this is worth doing and protecting. So if you're telling me that batteries only get replaced once or maybe 0 times, and it's not a huge margin product for them, then maybe, okay, changing the battery case space is not worth it. But I think all of these things use string as their dispensable product. It's the disposable razor part of their razor. Well, maybe it's worth spending some money. So I want to go talk to the accountants and find out how much margin they make on each cartridge, how many do they sell, and then use that as leverage to try to get them to make some changes on that part of the device.
Okay, but I'm going to pretend we're in the FMEA and I'm going to pin somebody down, and you just deferred to me pinning down Bill or Jim. So I want to pin somebody down right now because right now this engineering team, and I'm giving you, this is what I would deal with. Their management's like, we have to release in 3 months. Don't tell me we're going back and redesigning something because what if? That's what I get back. They're like 1 in a million. And I'm like, you don't get it. That's a lot. And they're saying, no, we're not, this is good enough. And I'm looking at you got Bill, maybe Bill's there in the room with me. I look at Bill, I'm like, what, do we just let him go with this or not? And I really don't know. So what, Bill or Jim, what would you say?
I'm going to invite Jim to play as if he was our personal injury plaintiff lawyer and tell you how that would play out, because I would be in the room with you, Adam, arguing for why we might want to document better, why we might want to have more explicit warnings, might want to have more plain language warnings, like do not let kids use this because kids do not have the judgment to use it properly. So we might go in that direction. But Jim, if you're acting as the personal injury plaintiff lawyer and your revenue is dependent on making a recovery, you don't get paid unless someone recovers, how would you approach this?
Well, what Frank has raised is a really interesting point on 2 levels. And it's one, I think the need for use case 7 has a relationship to how easy is it that we're going to encounter this. Adam, you and Frank had a discussion of using near field or some kind of RFID to ensure that, we can control certain outcomes. And so there's one aspect of it, but from another aspect, if it's feasible to implement something that makes a product safer, and by feasible, it's readily achievable, there's a design for it, it doesn't make the product overly expensive, then I think that the company should evaluate that, because the first argument that you're going to hear in litigation from, for example, a plaintiff's lawyer who represents a client who has been injured, might be, do you deny that this was feasible to do? And that creates a whole litany of issues for a product manufacturer in a case if they answer that, well, it was feasible and we decided not to do it. And, this comes back to some of the discussion that we had in our prior video about, talking about the 1 in a million chance. And I know, Adam, it's your opinion that that's low, but certainly there are things that might be categorized higher in terms of risk, and looking at, where those things fit in. So that would be my concern. It would be, is this a feasible change to make? And what are our options around this? And one of those things has to be looking at risk, occurrence, and probability, and all those kinds of things.
Okay. So now, Jim, I'm going to pull you into the situation again where I'm describing, because there's a level of high intensity in these situations when I'm in them. And it's because we have a lot to go through, a lot of analysis, and there's the conclusion drawn at that moment will direct what happens with it. There's not opportunities to do research, whatever. So, and so I have a lot of forces in the room that are against each other. I have the project managers who say the top 3 things that are important in program are time to market, and time to market. They don't care about anything else, right? And so you and I, Jim, have gone in there, and let's talk about this specific case and resolve it. So I've said, guys, if we do this use case 7 exercise, thanks for taking the time to do it, team. You can see that this is a possibility, that this battery thing, somebody could put in a battery that causes fire, you lose control for all these risks we just did for your product and all the mitigations we just did, off the table now. And you're saying, you're okay, team, that you've thought about that and you're going to make a little plastic shape to it that that has to be there. And I'm like, okay, great. But obviously if someone's good enough to engineer a battery, they're going to figure that out. And the project managers, yeah, we're not going back. We've already done our plastic molding manufacturing prototypes. We've invested $50,000 already, Adam, in hard molding for these plastic parts. To go back and redo all that alone, time-wise, is going to add another 4 weeks to our project. No. So then I'm going to say, well, I think you're leaving a very clear exposure. Then, Jim, what would you say in that specific situation if you and I have to make our case within those few minutes? Would you say, all right, let it go? You can show, I think that in this case, very specific weed whacker case we're doing, it's, fine, it shows good intent? Or would you be like, nah, Adam's right, you're leaving way too much exposure?
Well, and not to put it back on engineering, but I would want to know what's our expected outcome, or what are our potential possible outcomes? What are we actually doing?
Let's
with
play it
use
out.
case
Okay,
7?
so I'll play engineering.
Yeah, what are we going to do?
Okay, I'll play engineering because I want to do specifics. I want our audience. Last time we talked, more abstract theory. I want to do a specific one. So I'm going to say, okay, well, here's the thing. We go back through our FMEA thing. We have the risk of, with a bad battery, you can have a fire, lithium-ion battery fire. We can have the voltage be running way too high and it spins too fast, and then things break in ways that we can't predict, or there could be things that fly off. So we've identified that, and the way we've mitigated that is we made certain design characteristics for our battery that make it safe to fire and safe to this and safe to that. But we can't control what somebody else does, and we know those are real battery failure modes.
How bad is it to say, for this version, this is the one that's going out the door because we've already paid for the tooling and all that stuff, but version 2 will have the following changes based on XYZ. That's my concern for Adam and also for Jim and for Bill.
Okay, so you're saying that if the first generation hurts somebody, we can say we were aware of that and fix it in the second generation, and then the plaintiff isn't going to say, so you didn't care about my client?
Yeah, I think fundamentally with every product, there's always the potential for harm. Somebody can do something wrong with it somehow. So we can't completely design away all risk. We can't manufacture away all risk. We can't even warn away all risk. But what we can do is to manage and balance those possibilities along the way. So Frank, if we're going to do a round 2 and round 1 has a big problem, the next step we have to start thinking about is recall and warning and Consumer Product Safety Commission in this particular hypothetical. but other situations might be a little different, where the argument that Jim and you have with managers and engineers and investors is really one that says, what is the public's expectation of us? We have to create a product that is reasonably safe or that is not unreasonably dangerous, depending on which state's law applies and how any given state feels about product liability law at any time. There's not always a lot of certainty in the law about this, but there can be certainty about certain principles. One, you should make sure that your warnings really are practical and effective. Did you warn not to let kids use this? Keep it out of kids' use. If you buy a handgun, you don't want the handgun to be left on the kitchen table. Do you have anything similar to that with our weed whacker that says only use this if you are a competent adult, if you're 18 or older, if you're 21 or older? Have you warned people of the potential dangers that might come along the way? Have you explained why you should only use our battery? How about if in the owner's manual, we explain only use our battery because that's the way we've tested it. And if you use another battery, we're not as confident of the overall performance and the relative risks.
Oh, actually, okay. So just to stop you, would you consider that a sufficient resolution to me and the project manager almost getting the fisticuffs over the table? Would you be like, hey guys, wait a minute. You don't have to delay it. You don't have to make new molds. I believe that if we clearly state that we did use case 7, analyzed it, saw this as a risk, and we just documented in the manual, that's sufficient protection. Would you resolve our conflict that way?
I think conceptually my answer is yes. Now the devil's in the detail, because how thick can we make our owner's manual? What language do we use? Jim and I recently republished something on the White and Williams website about the kind of language that needs to be on a product warning and what colors and what fonts. There is a lot of detail in that, but the concept is, yeah, every product is dangerous. We're going to make a product, every has the potential to be dangerous. We're going to make it as safe as we can under the circumstances that we've got. And then we're going to document those decisions, and we're going to warn of the things that we think we should be able to warn about, including batteries, including aftermarket strings, including children nearby, and including the age of the user.
This is where it's fantastic to have you, the legal representative, thinking of use case 7 in the room, because that, if me only, that would have become a real throwdown fight that probably would have gotten escalated to another level. Because the only solution I would have offered is, no, we should add a barcode thing or whatever, like I was describing with, and that's going to add $3 per unit, which by the way ends up being $10 million in profit over 3 years. And you can imagine that. So that was one of the big things we hit in our earlier discussions, was really part of this legal use case 7 is have legal engage earlier in the process, even in technical discussions, right? You just posed a solution from your expertise that solved what I only saw as a technical fight, right? Like that's
I think it helps. I think it helps, Adam, when you've got somebody like Jim Berger who's defended these products in courtrooms. He knows what our opponents are going to do. He knows what the laws are in the states where he practices. Or even in other states where he's looked it up. And a guy like Jim can come into that setting during the product development phase and save you countless heartache and dollars by helping you to get past the risk and manage the risks up front. That's where it helps to have real product liability defense lawyers in the room. Transactional lawyers may know exactly how to frame the transactions of purchasing and sales, but you're going to need people who've actually dealt with product liability. I have a question though, Adam.
Yeah.
It's a very important question. I clearly am using an artificial background this afternoon because I've got really bad lighting in the backyard today.
Yeah.
Jim is in front of a false background.
Oh, don't do this. Oh, I know where you're going. Don't do it. Don't do it.
This is a multiple choice quiz. Is Frank Bruno is he housed in a box that's about to go over Niagara Falls? Is he housed in a magician's box where he's about to be sawn in half? Or is he in his son's bedroom closet? This is a multiple choice examination. Frank?
You didn't say D, all of the above.
Yeah. The cruelty.
Did you say that my background is fake? This is my office.
No, Jim. We know you're on vacation this week. You're at some bar down.
That's a picture of Jim's office.
It's a picture of my right. Yeah.
actually
But
his office. But
there is something that I wanted to add into Bill's, what Bill offered. And that's this concept of the safety hierarchy, where I think the top of the pyramid is you try to design away risk. And then if you can't design it away, you need to guard it. And then if you can't guard it, then you warn about it. And so even though I agree with Bill that there is a place for warnings, an important place for warnings, I personally would probably push back and be closer to Adam in some of these situations, because I cannot ignore the engineering principle of, you need to design away, then guard, and then warn. And so I would want to hear, we're talking about being in a room and looking at things on paper, what can we come up with in terms of guards here? Maybe the thing already has been produced, but maybe we can make retrofit a guard on something, or I guess that's similar to a design. But in any event, just wanted to add in my 2 cents there about warning is typically not the first line of defense in these situations.
Right. I think probably the most interesting summary from this discussion is, again, reinforcing the idea of, which is in the spirit of a good FMEA, is that you have people of multiple disciplines looking at the problem hypothetically from the start, and not this kind of series thing, right? Where, we're now saying legal also can be a great participant in that, even that early technically, because you poised an entirely different, solution than probably we would have gotten bogged down in, that then after we finished our fight over a long period of time, then maybe legal could have looked at it and said, well, why don't you do this? We think this actually would blah, 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 right? And it was inefficient. So I think that's,
I want to also be put to plug for adding a guard or something, to say that, when you're doing that, you are innovating, right? You are taking you have a very well-defined problem. My device is doing this, and I don't want it to do that. And I'm going to make a change that presumably your competitors aren't making, right? We haven't talked about what the other products on the market do. We're assuming this is totally in a vacuum. If everyone has a guard over that part of their weed whacker, then I'm assuming this is a different conversation. But we're sort of talking about it like Bill's company invented the weed whacker, and now we're going to go from there. My point would be to the room full of folks saying this is, the guard that you are designing might be a differentiating feature from your competition. It might be protectable intellectual property if it's a solution the world has never seen before. And so let's consider safety as a feature, not just a cost.
right. And then the opposing is going to be, there's going to be people on the engineering team that are like, you also just added $5 to a $45 product, and that's messing up our market point, right? But you're right.
People tell us that we can sell $6 more of weed whackers for every one of these because it's safer, then I'll use that as my counterpoint.
That's fantastic. Yeah. So that's another good thing. And it is a really good point to bring to conversation, is that, Volvo built a whole car company's, marketing plan on being, on safety features they added that cost more, but when you stop and think about it, that's a pretty good savings if you happen to be one of the people in a bad accident. So fantastic. Well, as usual, we went far beyond the time period we had set. We wanted to talk to you because it's good conversation, which means we're going to continue and do another one, I'm sure. But it was really great. I'm glad we dove into something much more specific so people could see how, how this would work and how it'd be beneficial. So thank you guys again for talking about legal use case 7.
Thanks, Adam.
thanks, Adam.
Sure. Have a good day.
We're going to edit.
We edited that out.
So Bill, look, I've got a good 2.5 inches between my head and the bottom shelf in my son's closet where he would study.
Whether or not people in your room recognize them or not. And the CFO
it's not COVID, it's allergies.
My wife painted it all black, and it's got like all this cool stuff. It's got like a whiteboard.